So one of the biggest questions I think I personally have, just out of pure curiosity, is what should an employer do if they receive a report that one of their employees has tested positive for COVID-19?
So Claire, you've stumbled across the singular biggest minefield issue that we're dealing with right now. And candidly, let me say this very honestly to you and to your viewers. We are right now making judgment calls on things that are only going to be judged in the aftermath. I don't know the precise right answer, but let me tell you the debate, and let me tell you what I think is the best policy for employers. Just before coronavirus exploded, just before this became a pandemic where we were sheltered at home, the EEOC, the Equal Employment Opportunity Commission, put out a message on its website saying that employers should absolutely avoid identifying the specific employees that may test positive for COVID-19. And the rationale they gave for that was that it would be an ADA violation, Americans with Disabilities Act violation. I looked at that and I said, I'm a little confused. And the reason I was confused is, first of all, any number of, let's call them non-permanent diseases or conditions, pneumonia, influenza, broken bones, people have tried to get those qualified as quote unquote disabilities under the and have failed in doing so. So in reading their justification and their announcement, A, I didn't know how that could be, but B, I wasn't sure why they were making that. But nonetheless, every lawyer in the world started pointing to that notice given by the EEOC, saying, well, you can't tell anybody. The other thing I said to myself, Claire, is what's going to happen inevitably is that at some point, an employer is going to be aware that someone in their workplace has COVID-19. It's probably not going to say something, and someone else is going to get hurt. Be that another employee who gets infected, or be that another employee who then goes home to a person who's at high risk. Well, it didn't take long, about 4 days for my prediction to become true, because just over 14 days ago, Walmart was sued in a massive, massive action here in the Northern District of Illinois, in Chicago, by an employee who died of COVID-19. And the argument, or at least one of the arguments made in the case is, you knew about this, Walmart, you didn't tell anybody, and somebody died as a result, and now you should be responsible. So the answer to your question, Claire, is there is no right answer. You're damned if you do, you're damned if you don't if you're an employer. But let me give you my thoughts on this one, and let me tell you what I think you should. If you're an employer who receives a positive report of COVID-19 notification, the first thing you should do is try to get a handle on who the particular employee was that's positive and who they may have interacted with when they were in the workplace. The other thing you want to figure out is, when was the last time that employee was in the workplace? If they went home 5 or 6 days ago because they were feeling lousy, then you at least have some cushion time when that employee left and the exposure of additional people afterwards. But if you can identify the people that were around that employee at that point in time, a shift, people working in the area, a team, a room, a cubicle set, I think it makes a lot of sense for the employer to reach out to that limited group, identify for those people the fact that a particular employee has tested positive, and warn all of them. That might be as strong or as stringent as asking them to self-quarantine if you can get them to telework at the same time. Or alternatively, it might simply be a warning to please watch yourself. Please figure out if you have any symptoms and be vigilant. More broadly, I think the employer at the same time should make a notification to the company without identifying the employee that in fact there has been a COVID-19 case identified. All of you should be aware and vigilant for your health.
And in doing that, that's not a violation of any sort of ADA anything, correct? If they just identify without saying which employee it is, but they give notice that we do have someone who's tested positive and we wanted to share that information to protect the rest of the employees. I mean, wouldn't that just make sense, because it's not in violation of anybody's individual privacy rights?
Very much so. A notification that someone has tested positive is not going to get you in trouble in some way. Let me give you the tagline that I give most of my clients. When it comes to the risks associated with identifying a particular employee, the group they may have interacted with, when we look at what the assessed fouls are going to be in the aftermath of this game, when we look at the game on Monday morning, I think the risks associated with making other people aware that they may be at risk are more worth addressing than the potential idea that an employee who has COVID-19 is either embarrassed or ashamed or feels some type of issue or way about the fact that the employer made other people aware they had COVID-19. Candidly, even though I feel for that employee, certainly if I had personal medical information or a circumstance like that, wouldn't necessarily want it spread. But the reality is for employers, better you get hit with taking measures to make other people safe, I think, than worry about the idea that the individual's feelings are going to be the issue in the aftermath.